More and more mistakes are being made by the lower courts to try to thwart your Second Amendment rights. This mistake that we keep seeing is between the notion of legislative facts and adjudicative facts. Why do you need to know this to fight for our rights? We're going to break it down for you when we come right back. Hey folks, I'm Mark Smith, host of the Four Boxer Don, a proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and I'm proud to say the top voice of the Second Amendment in America. Thank you, 2025 Gundies Awards. All right, folks, we need to cover this difference between legislative facts and adjudicative facts. This is a very big deal in the context of the Second Amendment because many judges are getting this wrong, and surprisingly, or maybe not so surprisingly, many of the judges that are getting this wrong are the same kind of judges that will look for ways to throw the Second Amendment under the bus. You know their names, you know who they are, and they're doing it. So why do we need to understand this difference, and why does this matter for your rights? Well, it's really quite simple. When the lower courts dealing with a gun control challenge, meaning a Second Amendment challenge to a gun control law, are faced with what to do to handle the case as a practical matter, here's what happens. The Second Amendment rights claimants, meaning the supporters of the Second Amendment, argue that this is a question of law. This gun control law is unconstitutional. It restricts my ability to have a gun. It restricts my ability to carry a gun. It restricts my ability to get a gun or whatever. It hinders my right. So as a matter of plain text, the burden shifts to the government to show a historical tradition of firearms regulation that somehow is analogous to the modern-day gun control law. And there's no such historical tradition that would justify the modern-day gun control law, and therefore we in the Second Amendment community should win this case, knock out this gun control law. That is what the Second Amendment argument is always about. And it should always be a winner, and many times it should be a winner. The problem is that the other side, the anti-gunners, the government arguments, say something like this: oh, we need to spend years studying this hard question. We need to take discovery. We need to get experts. We need to spend a lot of the taxpayer money defending this law, while at the same time forcing you in the Second Amendment community that wants to vindicate your fundamental rights by forcing, and we want to force you to spend a lot of money, a lot of time, a lot of wasted effort, all because, remember, never forget this rule, almost always the plaintiffs want cases to go fast and be resolved quickly. The anti-gun government defendants almost always want the government to go, a case to go super duper duper slow. Why is that? Because as the case is progressing in most instances, the gun control law the government is trying to uphold is in effect thwarting your right to keep and bear arms. So while the Second Amendment plaintiff wants the cases to go fast, the government and the anti-gunners want these Second Amendment challenges to go super duper slow. And what better way than to have these cases go slow than for the defendants, for the government to say, we need to do a lot of work. We need experts. We need discovery. We need a trial. We need to spend millions of dollars of our taxpayer money and millions of dollars of you guys in the Second Amendment community's money, all conveniently designed to slow down the process and deprive people of their right to keep and bear arms for as long as possible until we pack the Supreme Court and change the law in our favor anyway. But that is a no-go zone as a matter of law. Because as we've gone over before, as the Supreme Court has taught, when you're resolving the meaning of the Second Amendment, what does the text mean? What historical tradition is there? The questions presented in this context are known as legislative facts. These are facts that are determined about why was the Constitution enacted? Why was the statute enacted? Legislative facts, you see, bear on the justification or meaning of the legislation or the Constitution. Therefore, you don't need trials. You don't need any of the stuff that you normally need to figure out whether or not someone, for example, went through the red light. Legislative facts are things like, Thomas Jefferson helped James Madison write the Constitution when Thomas Jefferson sent books to James Madison, including Cesar Beccaриa's book on crimes and punishment that talks about how gun control laws don't protect the innocent. They only help the criminal. That would be a legislative fact. That the Second Amendment was adopted in 1791 would be a legislative fact, meaning you don't have to put on a testimony about that. The text of the Second Amendment is a legislative fact, right? You don't have to put on a testimony about what it says. The purposes behind the Second Amendment, the discussions, the writings, the Federalist Papers would be legislative facts about why the law was written or why the constitutional provision was written. You don't need to spend infinite money on experts and trials and testimony and depositions, which is what the anti-gunners want, because it's in their best interest to spend taxpayer money on upholding these laws and to slow the case down. And the anti-gun judges encourage this as well, because they understand that the longer they delay deciding on a Second Amendment case, the longer the law that they support, which is a gun control law, stands in place, cannot be knocked out. So that's what's going on here. So these lower court judges are declaring legislative facts that can be resolved by a judge in terms of what the law means and what the history of the law is. They pretend these things are what are known as adjudicative facts. Now, what are adjudicative facts? What are adjudicative facts? These are facts that are determined at trials. So while legislative facts are relevant to the constitutionality of, let's say, a gun control law, the adjudicative facts are things like this. If you're challenging an 18, 19, and 20-year-old gun ban for young adults, the first adjudicative facts is the plaintiff 18, 19, or 20 years of age? Does he live in the relevant state? Does he have does he have standing? In a different context, it would be like, did the parties, because adjudicative facts deal with the parties themselves. Did Mark go through the red light? Did Bob drive his car into the tree? Did Joe punch George? Did the bar close? Did the bar serve him alcohol? You see what I'm saying? These are adjudicative facts about the facts of the parties, involving the parties. When did he leave the party? See what I'm saying? These are adjudicative facts. They are different than legislative facts, which are about why a law was enacted, why the Constitution was adopted. What does the Constitution mean? But the problem is that the anti-gun judges, to help out the anti-gun government defendants, are substituting in the process you need to figure out what happened as a matter of an adjudicative fact. They're swapping that in and going through the same process that you would use to determine an adjudicative fact, but they're doing it in the context of legislative facts. But they're entirely different. Because unlike adjudicative facts, where you build a record and the court makes a decision of finding a fact, and when you appeal that fact, that adjudicative fact that Mark went through the red light, is considered basically established unless there's some clearly erroneous thing that occurred at the trial, for example. But that is not the case with legislative facts, which is really about, what did Andrew Jackson think? What did Thomas Jefferson write? What did James Madison say? Those are legislative facts. You don't have to call a witness to the stand or have a finding of fact by a trial court about these things, because they're legislative facts. And the consequence in the real world is this. If something is a legislative fact, you don't need trials, you don't need experts, you don't need to spend all that money on this. And if the trial court gets it wrong, the appellate court can reconsider it de novo. They can take on new evidence. They can think about all sorts of things, which is why in the real world, at the Supreme Court level, the Supreme Court was able to decide the meaning of the Second Amendment and the application of the Second Amendment in 2008 in Heller, in 2010 in McDonald, in 2016 in Caetano, in 2022 in Bruin, and just recently in Rahimi. These were all modern-day Second Amendment cases in front of the United States Supreme Court itself. How many trials occurred in any of these cases? That would be zero, except technically speaking, there was a short bench trial in Caetano because Jamie Caetano was caught with a stun gun, and the trial was just about, do you have a stun gun? Was it you? Yes, it was. You're convicted. There was no trial on the Second Amendment question in Caetano. There was no trial in any of these cases about the meaning of the Second Amendment. There were no expert witnesses at the trial court of any of these things involving the Second Amendment. None of the stuff that you would use to determine an adjudicative fact occurred in these Second Amendment cases that went to the Supreme Court. And the Supreme Court was comfortable in deciding the meaning of the Second Amendment in Heller, McDonald, Bruin, Rahimi, Caetano, all without any trial court work on the meaning of the Second Amendment to speak of. And that's because the question of the meaning of the Second Amendment and how it's applied in a court of law turns on legislative facts about the Constitution itself and not adjudicative. And this is mission critical because the anti-gun judges are treating legislative fact questions about the law as if they're adjudicative because it takes a lot more time and money to litigate in trial courts the question of adjudicative facts, which is like, did Mark act negligently? Did the doctor engage in malpractice? You see what I'm saying? That's a lot more work and a lot more money to figure out those questions than legislative facts and down at the trial court. Now, the reason why this is important, again, is because the anti-gun movement wants to sap the resources of the Second Amendment community by forcing them to do a bunch of work that they don't need to legally do. That's a big part of this. And at the same time, by forcing the lower courts forcing the parties to engage in discovery and other activities normally associated with determining adjudicative facts about the parties themselves, they are delaying the outcome of these Second Amendment challenges. And remember my rule, the Second Amendment plaintiffs almost always want the case to go fast. The anti-gun government defendants always want the case to go super duper duper slow. Because while the case is ongoing, that modern day gun control law almost always is in effect infringing upon the right to keep and bear arms. So the government wants that Second Amendment challenge to that law to literally take 100 years. Like the Jarndyce versus Jarndyce case in Bleak House and Charles Dickens. If you get that reference, boy, are you a nerd. Okay. So we know that the Supreme Court simply doesn't need adjudicative facts to decide Second Amendment cases because they didn't do it in Heller or Bruen. And there's some critical facts that get lost in history about Heller and Bruen that I'm going to bring to your attention right here and right now and make you very happy about this question. People forget that in the Heller case, the United States government, with Paul Clement, then Solicitor General, the U.S. government, filed an amicus brief and argued part of Heller, as I recall. Paul Clement, as the Solicitor General for George W. Bush, argued to the U.S. Supreme Court that the Supreme Court should not decide the Second Amendment question in Heller, but it should remand the case back down for further fact-finding about whether or not handguns are protected under the Second Amendment. And I'm happy to report that the U.S. Supreme Court in Heller rejected outright the suggestion by Paul Clement, the Solicitor General, and the United States government in Heller to send the case back for more fact-finding to determine whether or not a ban on handguns was constitutional under the Second Amendment. The Supreme Court's like, we don't need to do that. It's clearly unconstitutional. We can interpret the Second Amendment and apply it using legislative facts and the history of the Second Amendment, and that's what we're going to do and have a categorical rule that says you cannot ban handguns in the home because if you do so, it violates the Second Amendment, and we don't need further fact-finding or adjudicative facts, even though you, United States government, in your brief are arguing that we do so. We are not sending this case back for adjudicative fact-finding. It ain't happening. So too, by the way, did that same exact kind of argument get rejected by Justice Breyer and New York State in Bruen. Because in Bruen, you may recall, the Supreme Court said unequivocally that the right to bear arms means the right to carry arms, i.e. carry handguns in public for self-defense. There was no trial in Bruen. There were no expert reports in Bruen. There was no expert testimony or depositions in Bruen. None of the above. The case was decided, as I recall, like on a motion to dismiss. There was no witnesses, nothing, nada. And yet the U.S. Supreme Court in Bruen was able to say, as a matter of law, using legislative facts in the history of the Second Amendment, that indeed you cannot prevent Americans from carrying guns in public for the purposes of, among other things, self-defense under the Second Amendment. That is what they decided. But if you look at the dissent, listen carefully, folks, if you look at the dissent of Justice Stephen Breyer, he is literally arguing in his dissent in Bruen that the Supreme Court should remand that case back to the New York courts. It should be remanded back down to the lower courts for the lower courts to engage in all sorts of expensive and time-consuming fact-finding. And that is what New York wanted as well. And the U.S. Supreme Court says, no can do. No way, no how. These are legislative facts. We, the Supreme Court, don't need to have trials on this stuff. We're interpreting the meaning of the Second Amendment, the text of the Second Amendment, the historical tradition involving the Second Amendment, and gun control laws in America. We don't need trials. We don't need to deal with this like it's an adjudicative facts as to who punched whom first, who shot whom first. Those are adjudicative facts between the parties. We're deciding the meaning of the Second Amendment for 350 million people in America. We're not deciding specific activities and events that involved the parties themselves. We're talking about something much bigger and grander, and we don't need trials for these grand legal questions because we can use legislative facts, and we at the Supreme Court level and at the appellate level entirely can bring in facts that were not introduced, for example, at the lower courts, because these are legislative facts about Jefferson and Madison and Sam Adams and Lexington and Concord. You see what I'm saying? It's not specific to the parties. So anyway, folks, I want to bring you this critical distinction between legislative facts and adjudicative facts, because I can assure you there are many people out there in this great country that do not understand this difference. And even those members in the Second Amendment community who shall remain nameless continue to embrace the notion that questions about the meaning of the Second Amendment, including the historical tradition of firearms regulation, are somehow adjudicative facts, which justifies going out and spending a bunch of money and functioning and hiring experts and doing all sorts of stuff that legally speaking you don't need to do. Now, I should note this. You can do this if you want to. In other words, there's nothing illegal about going through all this insane process involving legislative facts and treating them as adjudicatory. In other words, if somebody wanted to do it, there's nothing that stops you from doing that, but it's not necessary and it's not legally required. And don't trust Mark Smith in the Four Boxes Diner if you don't want to. Just take a look at this exact question in the Supreme Court precedents of all those cases, Heller, Bruen, Catano, Rahimi, and so on, and take a look at the arguments the U.S. Supreme Court specifically rejected in both Heller, of Paul Clements in the United States government, and in Bruen, the dissent of Justice Breyer. So if you don't believe Mark Smith, that's fine. Take a look at Bruen and Heller and what the Supreme Court had to say on these very issues, and you'll see that the Four Boxes Diner is correct. All right, folks, so there you have it. Hope this was not too geeky for you. Make sure you subscribe, both to YouTube and to Rumble, and to check me out over there on X at Four Boxes Diner. And I look forward to talking to you again real soon at, you guessed it, the Four Boxes Diner.
Orders up. Table 2A.